Men in Black is the new bestseller from Mark Levin. He argues that the Supreme Court is destroying America by ignoring the Constitution and importing foreign law. This talk from the Heritage Foundation in Washington, D.C. is just under an hour.
Good afternoon, ladies and gentlemen. On behalf of the Heritage Foundation, I'm pleased to welcome you here to this meeting today and to talk about a very important book which is just come out and which I hope most of you will have the opportunity to read. As a matter of fact, we've facilitated that. We have copies available for purchase, and we have the author, who I'll introduce in a moment, ready here to sign those books. We also welcome our viewers on C-SPAN who will be watching this program. When Alexander Hamilton was writing in the Federalist Papers, he said that the Supreme Court, because it was the least powerful of the three branches, was the least dangerous to the liberties of the people. Well, Alexander Hamilton was a great soldier, he was a great statesman, but he turned out to be a very poor prophet, because I think many today have indicated that the Supreme Court is certainly as powerful as the other two branches, perhaps in some ways more powerful because it has the last word on many of the key issues facing our society, and some would also argue that it may be the most dangerous to the liberties of the people, particularly the people's liberty to engage in the political process and have a voice in the decisions that affect them in their everyday lives. Writing about this in the book Men in Black is Mark Levin. Mark has an outstanding background in public service and continues in that role, as well as now has become a commentator as well. He served in the Reagan administration in various capacities, but to me, most importantly, in the Department of Justice in various roles, ultimately as my Chief of Staff when I was the Attorney General. Today, he is the president of the Landmark Legal Foundation, which is a freedom-based public interest law institution. He is also a commentator on WABC in New York, has a 3-hour commentary right after Sean Hannity, I believe, every night. But he is also frequently commented on by Rush Limbaugh and occasionally on the Rush Limbaugh show, occasionally substitutes for Rush Limbaugh, and I believe will be on the Rush Limbaugh show very soon here within the next week or so about his book. He also is frequently on the Sean Hannity show and is referred to by Sean simply as the Great One. So I think that's pretty good acclamation by Sean Hannity. So it's a pleasure to have him with us today to talk about the book and about the judiciary, particularly the Supreme Court. Please join me in welcoming Mark Levin.
When I was growing up, the great one was Jackie Gleason, but I want to thank Ed Meese, who's my mentor, who I worked with in the Reagan administration, and who has taught me all the things that you'll agree with that I say, and the things you don't agree with, they come out of my own mind. And he's been a great friend and mentor for many years now. I wrote this book because it's time to talk honestly about the Supreme Court and the justices and the history of the court and what the court is and what the court isn't. I don't know why it's treated like an Olympian council, because it's not. I don't know why the justices are treated as if they're superhuman, because they're not. They're just as imperfect as the rest of us. The only difference is they have enormous power. The three most detestable events in American history, in my view, were slavery, segregation, and the internment of innocent American citizens. There's a fourth. I think abortion is too, but I'll put that aside for now. In each case, the Supreme Court upheld these abominations. In 1856, the Dred Scott decision, it didn't just uphold slavery, it imposed it on the free territories, even though Congress didn't want it. In 1896, it twisted the Equal Protection Clause of the 14th Amendment to rule that separate but equal is equal. That's not what it says. And in 1944, in my view, what it did in rounding up 110,000 American citizens, most of whom were Japanese. I don't give FDR and Earl Warren a pass on this, and took their property and moved them to the interior of the country without a single scintilla of evidence of wrongdoing. The Supreme Court upheld that too. You'll hear the left talk about, well, they upheld the minimum wage and all the rest of it, but the fact is that the Supreme Court's civil rights record is not that great. If any individual had a record like that, you'd think they were fairly bad. And yet we hold out this institution as the branch of government that is morally superior to the others. And conversely, the representative branches are viewed as the dangerous branches because they're actually susceptible to the public's will. How many times have we heard that as long as there's judicial review or that the judiciary is involved in the process, then our liberties are protected? Are they? How are they? And who protects us from a court that overreaches and abuses its power and endangers our liberty? Now, in the dissent in the Dred Scott case, Justice Curtis puts in a straightforward way what those of us who believe in originalism, original intent, reading the Constitution and giving, substance to its meaning, to its words, not looking for ways to skirt it. It was in the dissent that Justice Curtis said it best, I think, when he said, when a strict interpretation of the Constitution, according to the fixed rules which govern the interpretation of law, is abandoned, and the theoretical opinions of individuals are allowed to control its meaning, we have no longer a Constitution. We are under the government of individual men who, for the time being, have power to declare what the Constitution is according to their own views of what it ought to mean. This man was a hero. He opposed the ruling in Dred Scott. Then my friend Bob Bork, here's what he once said. Listen to the similarities. He summed it up this way. Originalism appeals to a common sense of what a judge's role ought to be in a properly functioning constitutional democracy. Judges are not to overturn the will of legislative majorities, absent a violation of a constitutional right, as those rights were understood by the framers. Moreover, he said, judges may look to the text, structure, and history of the Constitution, but are prohibited from inventing extra constitutional rights. Originalism seeks to promote the rule of law by imparting to the Constitution a fixed, continuous, and predictable meaning. Sounds a lot like the dissent in Dred Scott, doesn't it? But because he held those views, he was denied a position on the United States Supreme Court. The same views held as the dissent in Dred Scott. Now, some people have looked at the subtitle of my book and said, gee, isn't that a little harsh? Isn't that a little over the edge there, how the Supreme Court is destroying America? Well, let me ask you a question. If the President of the United States said, you know what, I'm going to decide what the law is in every instance. I'm going to decide if what the Supreme Court says is right or not. I'm going to decide if what Congress says is right or not, and there's nothing you can do about it. You think that would be tyrannical? Of course it would be tyrannical. Well, when lawyers do that, who happen to be Supreme Court justices, what else do you call it? If they won't comply with the Constitution and they're going to set policy in this nation, whether it's cultural issues or criminal issues, social issues, or at this point even the war on terrorism, what do you call it? I'll tell you what Thomas Jefferson called it. Way back in 1820, he was furious with John Marshall. He was furious with Marbury versus Madison. He was furious that the court seized power, called judicial review. He said, that's not in the Constitution. That was never contemplated during the Constitutional Convention. All we created in the Constitution was a silhouette for the judiciary. Yes, we gave the Supreme Court some powers, but we left it to Congress to determine ultimately what powers it would have, and we left it to Congress to establish the lower branches. How in the world can this silhouette be the most powerful branch of government? And he specifically put it this way: to consider the judges as the ultimate arbiters of all constitutional questions is a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy, which makes what I say rather tame, doesn't it? Our judges are as honest as other men, and not more so. And I can go on, but he was angry about it till the day he died. He'd be angry with Justice Ruth Bader Ginsburg. Justice Ruth Bader Ginsburg has written that a too strict jurisprudence of the framers' original intent seems unworkable. She added that adherence to our 18th century Constitution is dependent on change in society's practices, constitutional amendment, and judicial interpretation. She later remarked that, listen to this, boldly dynamic interpretation departing radically from the original understanding of the Constitution is sometimes necessary. Sounds like the justices in Dred Scott and Plessy and Karamazov. And the court has spent 200 years doing exactly that, for the most part. I'll give you some examples. The Commerce Clause in the Constitution, the purpose. One of the main reasons they decided to get rid of the Articles of Confederation and called the Constitutional Convention was because they wanted more trade, unobstructed trade between the states and individuals within the states. So they created the Commerce Clause to promote commerce. Well, today the Commerce Clause promotes big government. It limits commerce. How did that happen? Well, let's cut to the chase. In 1942, in a decision called Wickard versus Filburn, here's what the court said. I'll sum it up. Most of us consider commerce, where you actually have to trade something, or something passes from one individual to another, or there's a payment made. Here's another one of my heroes, Chuck Cooper. How are you, sir? This is what the court said in Wickard. It can hardly be denied that a factor of such volume and variability as home-consumed wheat would have a substantial influence on price and market conditions. So we're talking about a farmer growing wheat and consuming it himself. This may arise because being in marketable conditions, such wheat overhangs the market, and if induced by rising prices, tends to flow into the market and check price increases. But if we assume that it is never marketed, it supplies a need of the man who grew it, which would otherwise be reflected by purchases in the open market. So in other words, the fact that he didn't purchase in the open market influences commerce. Homegrown wheat, in this sense, competes with wheat in commerce. The stimulation of commerce is a use of the regulatory function quite as definitely as prohibitions or restrictions thereon. In other words, there are no restrictions on what the federal government can regulate. If commerce is interpreted as self-consumption, consuming that which you grow, then there are no limits. And so now the federal government limits how much water can flow through your flush toilet. That's how we got there. We have other tests that are remarkable. You won't find them in the Constitution, inventions of the court to set policy in this nation. This book is written for Main Street, by the way. It's not written for Harvard Yard. I don't much care what those people think. They've done enough damage to my country. I've written this for people so they can understand when the next judicial appointment is made what this fight is about. It's not about the left trying to smear outstanding candidates. It's about us and what we want from the court and what kind of government we want. And in the Griswold decision in 1965, any lawyers or law students here are well familiar with this case. Without getting into the particulars, it was another test that another liberal justice threw down. William O. Douglas, he wrote that specific guarantees in the Bill of Rights have penumbras, formed by emanations from those guarantees that help give them life and substance. Anyone know what that means? Nobody knows what that means because it doesn't mean anything. It sounds like Carl Sagan, emanations and penumbras. We have other tests that the court has created. Planned Parenthood versus Casey. Anthony Kennedy. He writes in part, "At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. Beliefs about these matters could not define the attributes of personhood were they formed under compulsion of state." That sounds like Oprah Winfrey. Scalia called this the sweet mystery of life passage. The Establishment Clause. Religion. In Wallace v. Jeffrey, 1985, in his dissent, Chief Justice Rehnquist, writing about the abomination that had become the court's precedents in this area, he wrote the following: a state may lend parochial school children geography textbooks that contain maps of the United States, but the state may not lend maps of the United States for use in geography class. A state may lend textbooks on American colonial history, but it may not lend a film on George Washington or a film projector to show it in the history class with respect to religious schools. State may lend classroom workbooks, but may not lend workbooks in which the parochial school children write, thus rendering them non-reusable. State may pay for bus transportation to religious schools, but may not pay for bus transportation from parochial school to the public zoo or natural history museum for a field trip. State may pay for diagnostic services conducted in the parochial school, but therapeutic services must be given in a different building. Speech and hearing services conducted by the state inside the sectarian school are forbidden, but the state may conduct speech and hearing diagnostic tests inside the sectarian school. Exceptional parochial school students may receive counseling, but it must take place outside the parochial school, such as in a trailer park down the street. State may give cash to a parochial school to pay for the administration of state-written tests and state-ordered reporting services, but it may not provide funds for teacher-prepared tests on secular subjects. Religious instruction may not be given in public school, but the public school may release students during the day for religion classes elsewhere and may enforce attendance at those classes with its truancy laws. That's where the court has taken us on the religious clauses of the First Amendment. They're incomprehensible. Just like so much of what the court does is incomprehensible. And why? Because when it leaves the standards and the guidance of the Constitution and goes off on policy decisions, it's no different than any other committee or PTA or council, and there is no guiding light except the views at any particular moment. There have been only about 120 justices in our entire history, and most people don't know who 50 of them are. Most people don't know who 10 of them are, and yet these people have had enormous power over our lives. 50. Some have been brilliant, some have been competent, some have been average, some have been racists, some have been crooks, and some have been senile. I told you we're going to rip the veneer off the court because these are human beings. These are not gods. God did not imbue these people with any superior abilities than the rest of us. I'm here to take a stand for representative government when it comes to the three branches of government, which is the branch of government that is put upon, which is looked down upon by the elites. The liberals can talk all they want about counting every vote. Pregnant chads, I don't even know what a pregnant chad is. Hanging, Cooper, you'd know what a pregnant chad is. A hanging chad, whatever went on in Ohio, they got upset about. Count every vote. But the truth is, they want you to count every vote of every justice, and they want to make sure that the justices share their ideological and political viewpoints. Because it's the justices, when they get into policy areas and impose their views on the rest of the nation, who are canceling your vote, who are disenfranchising the American people. And it's happening frequently. Now, these justices, as I said, there have been some very, very good justices, and there have been some very, very bad justices in every walk of life. I'm sure there's some very, very wonderful people here, and maybe one or two that are not so wonderful. I don't know you all. But let me give you some examples. We know all the great ones are. We hear them all the time. Let me give you some examples of the not so great, or some of the greats that had a few Achilles heel problems. James McReynolds. Now, McReynolds was appointed by President Woodrow Wilson. He was a notorious anti-Semite. He said he didn't want the court plagued with another Jew when Cardozo was up for justice position. There's no official photograph for the court for 1924 because McReynolds refused to stand next to Justice Louis Brandeis, the court's first Jewish justice. He would leave the room whenever Brandeis would speak in conference. He was also openly hostile toward the second Jewish justice, Benjamin Cardozo. As Andrew Kaufman has written, he often held a brief or record in front of his face when Cardozo delivered an opinion from the bench. And he was no better when it came to blacks. William O. Douglas. Oh, this is going to be controversial. I know he's a big icon of the left, and he served on the court forever. But he was imperfect, like all of them, but some are more imperfect than others. Arthur Bruce Allen. He's written Bruce Allen Murphy. This is a quote from his book. In a particularly bizarre episode, Douglas met a flight attendant on a plane and invited her to visit him at the court, where he allegedly assaulted her. Quote, just a short time after she entered Douglas's chambers, members of the staff began hearing strange sounds from inside. Sounds like the Clinton White House. Shouts, banging furniture, running feet. A short time later, the office door flew open, and out rushed the young woman, her face all flushed and her clothing badly disheveled, shouting at the startled office staff how outraged and disgusted she was. Douglas, she said, had chased her around his desk, grabbing at her clothes and demanding that they go to a motel immediately for a sexual liaison. Obviously, that's not his entire career. I'm just trying to point out that these efforts to make these justices look superhuman are just that. They're efforts. They're not reality. Thurgood Marshall. In his latter years, Thurgood Marshall had difficulty doing his duties. It's just a fact. And in his latter years, he would often watch soap operas. And he once told William Brennan that you're going to learn a lot from soap operas. I've got lists of these justices who had strokes and didn't know what decisions were being, what cases they were even deciding. We have President Taft, who met with 8 members of the Supreme Court because one of them was so infirm they didn't want any major cases to be heard by the court. What's the point of all this? To disparage the court? No. To bring it down to earth, to bring it back to earth where it belongs. Now let's go into a few other issues, if I might, quickly. The current court, for some absurd reason, is considered a conservative court. By any measurement, I don't know how it's considered a conservative court. Maybe it's not as bad as some prior courts, but I happen to think it is. Last summer this court ruled that foreign illegal combatants, that is Al-Qaeda and Taliban detainees, captured on the battlefield, held on foreign land at Guantanamo Bay, have due process rights. Now, they weren't clear exactly what due process rights. They have a right to, file a writ petition, that is, to ask a court why they're being detained. They have a right to have a lawyer. Beyond that, we're not sure, and the lower courts will figure that out. And 2 weeks ago, a Carter judge figured it out. They have exactly the same due process rights under the Fifth Amendment that we have. Yes, I guess they have to be Mirandized. I guess they can call witnesses from combat, men and women in uniform, to testify, to question their detention. They're going to all lawyer up, so if we need to get information to figure out if they're plotting to bomb one of our cities, we'll never get that information. I assume that's what she meant, Judge Green, when she said they have the same due process rights as all of us, because where do you draw the line? Either they have due process rights or they don't. I also assume that since illegal foreign combatants have due process rights under the U.S. Constitution, so do garden variety POWs. There have been tens of thousands of those, so they all get lawyers, I suppose, and they can come into federal court and raise all the same objections that a petty criminal can. Now, none of this is supported by the Constitution. In fact, back in the 1940s, the Supreme Court heard almost an identical case and ruled the other way. Justice Jackson, he ruled they can't come into federal court. They have no standing here. The commander-in-chief is in charge. That's the nature of war. There's nothing we can do about it, and there's nothing we are going to do about it. But the Constitution changed in that 60-year period, and now foreign illegal combatants have constitutional rights. Take immigration. The court has basically taken over policymaking in the immigration area. really starting about 3 decades ago, the court ruled that illegal immigrants have a right to public education. Now, where's that in the Constitution? It's nowhere in the Constitution. The late Chief Justice Warren Burger, in dissent, was really upset about this, about the court making policy decisions on budget issues, on all kinds of issues that only a legislature is competent to make decisions about. But William Brennan wrote the decision, and he didn't care much. The Supreme Court has also ruled that non-citizens have a right to compete for civil service jobs, that non-citizens have the right to be members of the bar, that certain residency requirements for non-citizens receiving benefits from a state are unconstitutional. So the court's all involved in setting policy on immigration issues. Let's do a few more. What about free speech? Well, free speech is almost as confusing as the religion clauses of the First Amendment. Free speech, okay? We have the court ruling that you can't protest within 100 feet of an abortion clinic, but Nazis can protest in a Jewish neighborhood. We have the court ruling that cyberspace child pornography is constitutionally protected, but certain broadcast ads 60 days before an election are not, and if you violate that law, you can go to prison. You can figure out that jurisprudence. I can't. Let's talk about the right to privacy. What does that mean exactly? I hear that phrase, privacy in the bedroom. Privacy in the bedroom. Well, a lot of things you can do in the bedroom that violate the law. You can kill somebody in the bedroom. You can rape somebody in the bedroom. You can conspire to overthrow the United States government in the bedroom. There are a myriad of crimes that you can commit in the privacy of your bedroom, the privacy of your home, in your front yard, in your house, wherever they're committed, they're committed. So that means nothing. That's a bumper sticker statement. It means absolutely nothing. But that's the argument the activists give to justify their decisions when it comes to cultural and social issues. The question isn't who's in the bedroom, because the government is in your bedroom. The question is which branch of the government and what are they doing there and how do we influence what they're doing there? I can tell you this, the 9 lawyers on the Supreme Court, when they make the decision, they're there and they're staying there, and there's no getting them out. Let's talk about this wall of separation between church and state. Everybody who's serious about this subject knows what the framers meant. We know they meant that they did not want an official state religion, the kind they escaped from. They did not want people being taxed to support this state religion. They did not want people being punished for not adhering to this state religion. That's what they were concerned about. They even allowed states to have their own religions, official religions. Now, nobody here is promoting that viewpoint. American people don't support that. American people will never support that. But the American people do like the Pledge of Allegiance. They don't mind if there's a nativity scene or menorah on public property or 10 Commandments, because you don't have a right not to be ticked off. You don't have a right not to be offended. You have a right not to participate in an official state religion. So where did this wall of separation come from? Everybody says Thomas Jefferson, his letter to the Danbury Baptists. As a footnote, that letter was written years after the Bill of Rights were adopted. So it has absolutely nothing to do with the Bill of Rights. In fact, Thomas Jefferson had absolutely nothing to do with the Bill of Rights. And in fact, he had nothing to do with this. In 1947, in a case called Everson, Justice Hugo Black, who was appointed by FDR, prior to that he was a senator from Alabama, and prior to that, among his extracurricular activity, he was a member of the Klan. He was vehemently anti-Catholic. Now, how do we know this? Because his son wrote a book, a biography, and said so. And he was anti-Catholic while he was on the bench. These feelings, you know, they're hard to, you know, when you hold them so deeply, they're hard to get rid of, whether you're wearing a black robe or not. It's a very bizarre decision, because while the court upheld public funding for bus transportation that included taking kids back and forth from Catholic school, Black slipped this language into the Constitution about a strict wall of separation. And so When you hear Michael Newdow make this statement, when you hear the ACLU repeat it, when you hear all these other groups and individuals say, yes, wall of separation, just remind them they're quoting a former Klansman. I like to remind them of that myself. Let's talk quickly, if I may, and then I'll take some questions about what is about to happen. And what is about to happen is the President of the United States is going to nominate at some point hopefully a new justice to the Supreme Court. Maybe more than one. Whatever. The fact is that there are organizations around this city, Washington, that are already prepared to smear them. No matter who they are, they're prepared to smear them. They're bragging to the media, oh, we've got all these computers set up, we've got all these volunteers, grassroots operations going, we're ready to go, we've got dossiers that are this thick. And now, why are they all worked up about this? They're all worked up about this because the only way they can advance their agenda is through unelected judges. When they run for office on their agenda, they lose. A lot of times when they run for office trying to conceal their agenda, they lose. But they've had a bad line of losses over the years, and the one place they can rely on is the court, because it appears that no matter who's elected, the court just keeps moving in one direction, in an activist, liberal direction, in which the justices continue to impose their personal policy views on the rest of the nation. This is why Ted Kennedy and Dick Durbin and Barbara Boxer and the rest of them will do whatever it takes to block or to smear or somehow obstruct whomever the president nominates for any opening on the Supreme Court. They will even risk losing 1 or 2 or 3 of their more moderate members in red states because they must hold on to this branch of government if they have any chance of advancing their agenda. And that should tell you something right there. That is, that the will of the people doesn't seem to matter, at least to them. Now, my own view is that the impetus is on the Republican leadership in the Senate to stop talking about what they're going to do and actually do something about it. In the first moment that there is a threat to filibuster one of the president's Supreme Court nominees, they should use the majority status and crush the opposition. They should use the majority status and reinstitute the constitutional procedures that the American people expect. They should crush efforts by the small cabal on the left to undermine the Constitution and the president's power to appoint a Supreme Court justice. They need to change the Senate rule that allows the use of the filibuster for judicial nominees. It's really that simple. The Constitution provides 7 instances in which there's to be a supermajority vote. This is not one of them. The Constitution provides for advice and consent by the Senate. I know this because Chuck Schumer keeps telling me this. Well, I say to him and the other members of the cabal, that means the whole Senate, Senator, not just you and 40 of your friends. All the senators get to give their advice and consent on an up and down vote. And since they're abusing the Senate rules, there's nothing magical about the filibuster. There's nothing magical about the Senate rules. Change them. Now they call this a nuclear option. A nuclear option because they want everybody to say, oh my God, they're not going to change the Senate rule, are they? That's the nuclear option. Well, they already fired off the nuclear option, the liberals did, when they started these unprecedented filibusters against candidates who have majority support on the Senate floor, but they just can't get the vote. This is the constitutional option. This is the option that says, okay, we're going to change the Senate rule for good. I think if Mr. Frist and the others explain it to the American people, that the American people will support them. The American people do not support this small cabal of left-wing senators. Just look at their numbers. And let me just say finally, as I say, I've written this book for what I'll call regular Americans, not elitists, not liberals, not the media, not academia, although they could learn something too, but they won't. I wrote this book for this audience, so they understand what the court was supposed to be, what the court's supposed to do, and what we can do about it. I have a few suggestions. People have told me they're very controversial. Well, I think the court seizing power and issuing policy decisions is very controversial, but I don't think all my suggestions are. But the point is to start a debate and try to debate some ideas, ways that we can readjust this balance between the branches. Constitution's fine, it's us. We need to fix what people are doing to it. First of all, the Constitution already authorizes Congress to determine how many members of the Supreme Court there are going to be and what powers the Supreme Court will have outside of certain specific responsibilities not relevant to us here. It also authorizes Congress to establish lower courts if it chooses to, and to determine the nature of those courts. Early in our history, Congress did it. Did it all the time, as a matter of fact, 3, 4, 5 times. Congress doesn't do so much of that anymore. I mean, it would be nice if they would, for instance, break up the Ninth Circuit. So, the independence of the judiciary. Can't have that. Excuse me. The Constitution gives this power to Congress. Nobody's saying Congress will rule for the court, but Congress can establish the courts the way it chooses to. There needs to be some thought given to that. There are House members who've made some valiant efforts to push this, only to be stymied in the greatest deliberative body that man has ever known, called the United States Senate. I have 2 other suggestions. I really do believe in term-limiting justices now. I never did, but I do now. As long as they're going to serve as legislators, as long as they're going to set policy, then they don't need to serve for life. They can run for office. There are many great people who can serve in those positions. The issue is no more one of ensuring the independence of the judiciary. It's one of ensuring the responsibility of the justices. So I've come to that view after a lot of thought and consideration. And, you know, maybe 12 years is enough. The average justice has served almost 14 years. And frankly, if you look, as they get older, a lot of these justices just don't want to leave. And since there's only 9 of them, it's probably a good idea that we, the people, through an amendment, tell them that it's a 1-term, 12-year term. The other proposal I have, which is my most important, at least to me it is, and probably the most controversial, is this. Let me put some context in first. The framers were concerned that the president would be too powerful. So on legislative matters, they decided that, yes, the president can veto legislation, but ultimately Congress can override it with a supermajority of both houses, 2 votes. Well, today it's the Supreme Court, and believe me, the framers would never have believed it, but it is the Supreme Court that, in my view, is the most powerful branch, and specifically the lawyers on the court. Yes, I know they're justices, but they're only human beings. They're lawyers. So my view is that the same thinking that went into the supermajority override of a presidential veto ought to go into the possibility of both houses of Congress with a supermajority overriding a Supreme Court decision. That would mean that the court does not always have the final say, but the public, vetted through the representatives through a supermajority vote. Supermajority votes aren't easy to get. I can't remember the last time. I mean, I haven't checked it, but they're not easy to get. Senate still filibusters everything. But I really feel the final say in truly extraordinary circumstances that Congress should have a tool to have the final say. That is, we should have a tool. And I wouldn't be proposing this if the court, in my view, wasn't out of control. And it's interesting, when I say how the Supreme Court's destroying America, you should read some of the dissents in some of these opinions. The other justices are saying, we don't have the power to do this, we shouldn't be doing this, who do we think we are? Well, if you don't have the power to do it, and you're exercising it anyway, then that's tyranny. That's tyranny. But we can fix this. I'm hoping we can engage the public in this, get the public involved in the Supreme Court, understand that these are mere mortals like the rest of us, stop allowing the left to determine the context of this debate, and prepare ourselves for the next nomination of the Supreme Court. Thank you for listening. Appreciate it.
As Sean Hannity would say, tell us, Mark, what you really think. Mark will now entertain questions from the audience. And when you ask a question and I recognize you, please wait until you get the microphone and then state your name and then ask your question. Right in the back there.
My name's Hollister Candace. I have one question with two aspects.
We call that a two-part question. I'm just kidding.
My hunch is you're going to have one answer.
Yeah.
How do we keep the Constitution up to date with modern mores and policies? Is that fat enough a question? And the other part of it is, how do we walk the cat back? How do we go through all those decisions, like the ones that you mentioned, and get them changed? Is that one act of Congress, one by one by one?
Let me address the first question. It's a very good question. I hear it all the time. How do we update the Constitution? Well, what do we want to update? I don't understand. Do we not like our form of government? That's all the Constitution is. It's 3 branches. Is there something that needs to be polished or sharpened? I'm not aware of it. If the American people think something needs to be modified, then we have an amendment process. It's not a question of updating the Constitution. The Constitution, by its very terms, sets principles that we believe in as Americans. We believe in representative government. We believe in divided government. We believe that the best government is local government. But we believe there are certain functions the federal government should be in charge of. That's the reason there's a Constitution with enumerated powers. We believe there should be courts doing their job. We believe the commander-in-chief should be in charge of the military. We believe Congress should be the body where the House in which tax bills come up and so forth, and the Senate should approve treaties. I've never understood we need to update the Constitution. We don't need to update our principles. Our principles are forever. Maybe we need to update our thinking as individuals. What do we want from our government? But that's not the Constitution. That's us. What policies do we support? When I talk about, for instance, the changes that I want to the Constitution, it's not really a question of updating the Constitution, but it's a question of addressing what I consider an abuse of power that the framers never considered. And so what we need to do is address that in a way which would be amending the Constitution. As to your other question, how do we unravel these things? Look, unlike the justices, I know I'm not imbued with all this great knowledge and brilliance. I'm just a regular working man here, and my own view is that we do it by getting this debate going, making sure people are pointed to the court who have respect for the Constitution, the representative branches of government, and ultimately the will of the people, and perhaps debating some of these modifications. As I say, Congress already has power to affect the makeup of the judiciary. What's missing is the engagement part of the American people. We're in a representative republic. That's the way we make change. It's a long process.
Okay, down here, either one of those two, and then we'll get the other one.
Dave Breikenrucker with the Bill of Rights Foundation. Excuse me. It seems like what you were saying is that on Marbury versus Madison, that Justice John Marshall was making a power grab, if I understand what you were saying. If so, if you don't think judicial review is a function of the court, exactly, could you enlarge on exactly how the court would do its business? What is it supposed to do?
Well, let's first, the most important point is to get our history exactly right. The Constitution does not provide for judicial review. So we do need to at least admit that, right? That's why we have Marbury versus Madison. That's why his decision so outraged Thomas Jefferson. And you won't find any arguments during the Constitutional Convention in support of the Supreme Court having the final decision on all constitutional matters. The court is supposed to adjudicate issues that come before it. If there are constitutional issues and it has a position, it takes a position based on the Constitution. Congress has some power to interpret the Constitution, too. It can do it through the powers that I've already talked about if it disagrees with the court. President has some powers, too. I mean, I know the last time a president dared to exercise those powers, it almost became an article of impeachment. For instance, the president decided in Nixon's case that he was going to impound funds. Yeah, they can pass a bill, but I don't have to spend that money. Oh, my God, what did he say? He doesn't have to spend that money? Well, he is in charge of the executive branch, so he was exercising his power. But the point is that the court, I don't have a problem with judicial review per se, but let us understand that it's not in the Constitution. Let us understand when the courts exercise it, they have to do it with incredible restraint. They're exercising a power that's not in the Constitution. It may be exercised as a practical matter. But if you're going to do that, then you must show absolute restraint. The problem is that the court has taken a power that's not in the Constitution and run wild with it. Just look at the latest decisions. We have 5 justices on the Supreme Court today, either through their speeches or their opinions or both, who have ruled, who have said that they will rely on foreign law and foreign court decisions when they feel necessary to help guide them in making their decisions. That is a brazen violation of the Constitution, completely undermines representative government, because we have no input on any of those laws, and it is abuse of judicial review. That's why I'm arguing for an amendment that would give Congress some additional power, with the 2/3 of both houses a supermajority veto of a Supreme Court decision. At least that's more legitimate if it's passed through the constitutional process than the court simply seizing that power, as it did in 1803. The counter-revolution of 1803, as Jefferson called it.
It seems to me your book in itself is a major step or important step in changing the political culture of what we understand the Supreme Court to be. It's without amending the Constitution, it seems to me if more people took responsibility for understanding and interpreting the Constitution, beginning with Congress and the President, countless times we see members of Congress voting for legislation, believing and stating publicly they don't believe it will pass constitutional muster, but they, having sworn to uphold the Constitution, still vote for it. Presidents sign it with the idea that the only people who should really speak on the constitutional merits are these 9 justices. And if the political culture forced the President and the members of Congress to uphold their oath and not vote for things that they felt were unconstitutional, and when the Supreme Court did something that was outrageous, that the broad culture denounced them for egregious seeking of power, it seems to me we might rein them in without necessarily amending the Constitution, but just forcing them to do their job and not more.
Well, you're exactly right. Unfortunately, it hasn't worked for over 200 years, but you're exactly right. The concept was that the other branches would jealously guard their power, and they haven't. And you're right. I mean, the most recent example is McCain-Feingold. We signed that, sent up to the Supreme Court. They'll do the right thing. Well, they did the wrong thing. And now look at the mess. The other branches have a duty to uphold the Constitution, too, and that means exercising their legitimate authority and exercising in a way that is juxtaposed to the illegitimate authority exercised by, say, the court. You're exactly right. But it's up to us, ultimately, the public, to get involved in this. I'm trying to broaden the debate on this issue so it's not just a law school academic discussion. That, you know, my callers to my radio show on WABC in New York all through Christmas, you know, what are these courts doing? What are they doing with the nativity scenes and Santa Claus and Christmas trees and all the rest of it? Well, just go to the ACLU's website. They have an entire strategy to attack any religious symbol in any public place. Okay, so what are we going to do about it? Whine about it? This is supposed to be the greatest representative government man has ever known. It really is. But it's time for the representative part to reassert itself. That's my point.
What other questions do we have? Down here.
Is he allowed to ask a question?
Well, since no one else would ask you one, Mark, I just wanted to, ask you about one other aspect of the Democrats who are engaging in the obstruction in the Senate, what they refer to as the nuclear option. There's certainly an implication in that they will throw a horrible temper tantrum if they don't continue to get their way, that they would act out of spite on some other issue if their temper tantrum over the judges is ending. Can you speculate what they're trying to say, what possible harm could befall the Republic if we Don't let them continue to have their way?
Well, let's see what they've done so far when they're in their behaving mode. What they've done in their behaving mode is Barbara Boxer went to the Senate floor in a completely outrageous act and challenged the electoral vote. Everyone knew she would lose, but she did it to embarrass the president, wound up embarrassing herself. They viciously attacked Condi Rice and questioned her integrity. They have viciously attacked Alberto Gonzales and questioned his integrity. What else can they do? And frankly, who cares what else they do? There are 45 of them, and if they want to take that position with the voters, that's great. I am not persuaded that we have to be shaking in our boots in fear when I'm speaking for myself, when the Republicans have 55 seats. You know, it's not as if this is the toughest thing Congress has ever faced. There was a time we had a civil war. Now, that was a tough Congress. They actually had to do something, and they actually had to stand up. We're talking about changing the Senate rule. We're talking about standing up for the Constitution. If we can't make that case, then why are we in the majority, is what I'd like to know. And we ought to make the case now and tomorrow and every day, and as soon as they come up, smack it down. Win the day, and win it not just for the president, but win it for the Constitution. If this Congress leaves without having changed that filibuster rule, and with the minority successfully filibustering a Supreme Court justice nominee, then that's going to be our history, the filibustering of judges and Supreme Court nominee and justices. That ought not be our history. This Congress has to stand for all time. It has to protect the Constitution. I don't much care about any of the other legislation, I'm just talking personally, which will have probably no lasting effect. This has to be beaten back.
Up here.
Uh-oh.
I'm Chuck Cooper, and first I want to congratulate my old friend Mark on
My buddy.
making this very important contribution to this extremely momentous debate at this time especially. Mark, I was especially gratified to hear you say that the life tenure of federal judges is at least one of the things, I think, at the root of the difficulties we see now with really an entirely unaccountable, all too independent judiciary, especially the Supreme Court. I came to that view some time ago myself, but I'm wondering if your thoughts on the life tenure idea and term limiting judges has included a change in the way in which justices, for example, come to office. Are you calling for elected federal judiciary or just the limits on their term?
I'm just calling for limits. You know, I've been in front of elected judges, and doesn't necessarily make them better. I've been in front of judges, you know, who were elected because they knew boss, whatever his name was, in county XYZ. No, I don't want to turn the judiciary into an elected branch of government. I really don't. I want to turn it into a responsible branch of government that is supposed to do what it's supposed to do. I don't want a judiciary, and the framers didn't, that is reflective of the body politic. We want a judiciary that's going to comply, that's going to follow the Constitution and comply with the language. So no, I don't want cheerleaders on the Supreme Court or the federal courts for one point of view or another. People just want a fair hearing. They want to know that the rules are set. They want to know that policy will be decided in the other branches, and that when they're in front of this court's going to give it its best effort to actually interpret the Constitution and not carry some agenda. You know, Harry Blackmun, the justice who wrote the decision in Roe v. Wade, one of his clerks talks about how he actually became influenced by fan mail. And so he was the advocate for abortion, period. There was nothing was going to change him, no arguments, no constitutional arguments, nothing. No act by Congress, period. And he became that way also on gay rights and anti-death penalty. And they say he was very influenced by the mail that he got. I don't want that either. No, these people are supposed to be mature, serious, experienced lawyers. You don't have to be a lawyer, obviously, but that's what they are these days, and who are on the court, who have a job to do. And as the gentleman said before, you know, judicial review, if it's not them, then who? Well, if that's them, then they have a special responsibility to understand what their role is and to comply with it. They're not doing that right now. Just read their decisions. They're not doing that right now. So it's time for the American people to do something about it.
Mark, one more question. Last question.
I'm sorry not to get up, but it's hard from here. D.C. Gray, I wanted to follow up on Chuck's question a little bit. I wasn't clear if you were saying that only justices of the Supreme Court should be term limited or all federal judges. But
All.
Okay, well, let me put this in the mix for you to think about then. Federal judges now have all kinds of economic incentives to go to senior status when they turn 65. The Supreme Court does not share those incentives. So I would suggest, maybe you might think about this, that either some incentives be put in, economic incentives or other, to bring the justices to want to retire, as other federal judges often do because of the incentives at 65. Or two, if you are suggesting term limits, I would think you might want to consider putting it just on the Supreme Court, and I would suggest 18-year term instead of 12, and here's why. Because that would mean that every president would get, they would know that an opening would be coming up every 2 years. Each president would get 2 elections per term, and there would be a plan which gives us a nice rotation, more than I think 12. So I'd like your comments.
You can do a rotation with 12 years. The problem with 18 years is the average service is about 14 years. We don't want to do outside. I'll challenge your calculations. I can't do it right in front of you because before I put that in the book, we went through every single term of every Supreme Court justice. As for encouraging them to leave and giving them an incentive, great, I don't have any problem with that. But most of these people are not going to leave. They're there because they want to be there. Most of them already know that if they left the bench, they could make a fortune in the private sector. So I'm not exactly sure what incentive it is that we give them. It's very hard to incentivize the returning power to the people. So rather than incentivize, go ahead and take your position. I have no problem with a number of positions being argued. My view is whether you are affected by incentives or not, you're off. 12 years is it.
Mark, thank you very much. Thank you all, ladies and gentlemen, both for the excellent questions and for your attention. At this point, Mark will be here. He will be prepared to sign your books if you'll form a line over here, those of you who have purchased. Those who haven't purchased, there are still books available outside. Thank you for being with us.
Mark Levin is president of the Landmark Legal Foundation. Men in Black is number 4 on this week's New York Times nonfiction bestseller list. It's published by Regnery. Visit them on the web at regnery.com.